to the organizers of this important program, which really is the premier white-collar conference in the country each year. It's a pleasure to be here in New Orleans, a place where I spent a lot of time when I was in private practice. Mark Twain once observed that New Orleans food is as delicious as the less criminal forms of sin. I thought that was a fitting quote for this event, and I hope each of you is getting a chance to engage in a little bit of culinary sin this week, even if Mardi Gras season ended on Tuesday. I also want to say thank you to my criminal division team, many of whom were here this week and participated in panels that I hope you found informative. John Cronin, my principal deputy, Matt Miner, Deputy Assistant Attorney General over the fraud section, Rob Zink, Joe Beamsterboer, Dan Kahn, and Deb Connor. Some of these folks I brought into the department with me. Others of them I inherited, but as a universal matter, they are a fantastic team and a group of people who I rely on heavily every single day. So thank you all from the criminal division team for being here this week. Events like this provide an invaluable forum for practitioners, prosecutors, and law enforcement, many of us who often sit across the table from one another, to exchange ideas and perspectives and to discuss areas of mutual interest. I want to reflect today a little bit on those areas of mutual interest because government enforcers and industry are so often painted as adversaries. But that simplistic view ignores how frequently our individual interests actually do intersect. Financial fraud and corruption threaten private competition as well as the public fisc. Effective white-collar enforcement promotes market integrity and fairness, as well as fundamental values of democratic accountability. And prosecutors and companies alike each bear a critical responsibility, both in deterring corporate misconduct and also in addressing that misconduct when it occurs. Our mutual interests, however, don't necessarily guarantee mutual trust. And at the Department of Justice, we recognize that transparency often can be the key to advancing our mutual interests with the many responsible members of the corporate community. After all, when companies understand what conduct will be credited or penalized, the more likely they are, as generally rational actors, to implement effective compliance programs, and upon finding misconduct, to voluntarily disclose it, cooperate with the government, and remediate. And the more likely they are to work with the government, not against us, and to choose a course of action that ultimately advances the rule of law. Since rejoining the department last year, I've made it a priority to foster transparency in our corporate enforcement practices. We've sought to promote transparency in both our general policies and our case-specific resolutions, some of which I'll talk a little bit about today. And we further promoted that transparency through a focus on both the clarity and the detail of the policies themselves, as well as their effective dissemination within the department, in other parts of government, and to the public at large. There can be no doubt that today's law enforcement challenges are many and varied and complex, but the department's commitment to white-collar criminal enforcement and the promotion of ethical business practices remains as strong as ever. And you didn't take my word for it. The numbers bear this out. Whatever reporting you may be reading about white-collar enforcement being down at the department, just listen to some numbers. In fiscal year 2018, the department as a whole charged more than 6,500 defendants in white-collar prosecutions, which was a modest 3% increase over the previous year. But in the criminal division, which I oversee, the numbers were even greater. In 2018, our fraud section prosecutors charged 406 individuals, won 268 convictions, and brought 10 corporate enforcement matters. They recovered more than $1 billion in domestic corporate criminal fines, penalties, restitution, and forfeiture as part of resolutions that returned more than $3 billion globally. The number of individuals convicted at trial in 2018 in fraud section matters marked a 40% increase from the previous year. And the number of individuals charged in 2018 was 33% higher than in 2017. The fraud section securities and financial fraud unit charged 66 individuals in 2018, up from 57 individuals the year before. And the FCPA unit charged 31 individuals in 2018, up from 24 individuals the year before. Meanwhile, our healthcare fraud unit, which also oversees our Medicare fraud strike forces, charged 309 individuals in 2018, a 40% increase from the previous year. And we dramatically expanded those strike forces in 2018, establishing new teams to concentrate on healthcare fraud and opioid cases in 12 federal districts, including Philadelphia and Newark, New Jersey, and all across the Appalachian region. As the numbers suggest, we remain steadfastly focused on holding culpable individuals accountable, which I think everyone understands is the most effective deterrent to corporate crime. At the same time, however, we've also remained steadfast in our efforts to hold corporations accountable whenever their conduct warrants an entity-level resolution. In fact, just yesterday, Mobile Telesystems PJSC, or MTS, the largest mobile telecom company in Russia, entered into a DPA with the department in connection with FCPA violations in Uzbekistan. The case involved an elaborate scheme with a staggering $865 million in bribe payments. That represents 2% of Uzbekistan's GDP to one former Uzbek official. The bribes were designed to secure the official's assistance in the company's entry into the Uzbek telecom market. As part of the agreement, the companies agreed to pay a combined penalty of $850 million. MTS agreed to a 3-year monitorship, and MTS's wholly owned Uzbek subsidiary entered into a guilty plea to conspiracy to violate the FCPA's bribery and books and records provisions. And we announced charges against 2 individuals, the former Uzbek official who took nearly $1 billion in bribes, and the former CEO of another MTS subsidiary. The department's white-collar prosecutions and resolutions send an unmistakable message to the private sector. We're serious about fighting corporate fraud and corruption, and we're serious about doing so through resolutions that are fair and effective. That means, as an initial matter, that we aim to be as transparent and consistent as possible about the criteria we apply in exercising our prosecutorial discretion. We strive to be open books about which factors we find aggravating, which ones we find mitigating, and how each is penalized, credited, and ultimately weighed. It also means, more fundamentally, that we want to convey to companies the right incentives for responsible corporate behavior. We want to avoid penalties imposed just for penalties' sake. If a company faces other civil or foreign penalties for the same misconduct, we'll apply our piling on policy to reduce or apportion financial fines, forfeitures, and restitution between authorities to ensure that the overall outcome is equitable and just. We also will avoid penalties that disproportionately punish innocent employees, shareholders, customers, and other stakeholders. Each of these guiding principles helps ensure that companies and their advisors, with better visibility into our decision-making process, can make their own well-informed decisions going forward. Of course, the department conveys its approach to white-collar and corporate enforcement not simply through the cases that we prosecute, but also the ones that we don't. The department's FCPA corporate enforcement policy is at the forefront of this effort. The policy lays out in plain terms how we assess FCPA violations based on our evaluation of specific actions taken by a company in the face of misconduct. By formalizing and memorializing the department's declination criteria in the Justice Manual, the policy conveys to both prosecutors and to the public that we will reward companies that act responsibly upon uncovering criminal misconduct. As many of you know well, the corporate enforcement policy details the standards for what constitute voluntary self-disclosure, full cooperation, and timely remediation, providing for a presumption of a declination when a company meets these conditions. It also lays out various aggravating circumstances that could potentially overcome this presumption. And it details reductions to fines and prosecutors that should apply if aggravating circumstances call for a criminal resolution with a company that has voluntarily self-disclosed. At bottom, the policy fosters transparency about when credit is due and how we will award that credit. With that information, companies and their officers will be better equipped to engage in rational decision-making about the steps they should take to qualify for a declination. At the end of the day, companies that voluntarily self-disclose, take steps to prevent misconduct through robust compliance programs, and take appropriate remedial steps when misconduct is detected should know that they will get a fair shake from the Department of Justice. To further promote transparency, we've made publicly available all of our case declinations to date under the FCPA corporate enforcement policy. There currently are 12 declination letters published on the department's website. Each sheds additional light on how we apply the corporate enforcement policy to different facts and circumstances and the determinative factors in our resolution. The most recent of those 12 letters involves our decision just last month not to prosecute Cognizant Technology Solutions Corporation, a publicly traded Fortune 200 company, for FCPA violations. Certain high-level employees and agents of Cognizant allegedly participated in a scheme through which they authorized a third-party construction company to pay approximately $2 million in bribes to Indian officials for helping a planning permit related to an office park project. Notwithstanding the fact that the misconduct reached the highest levels of the company, we declined prosecution, and we've made it clear why. The company voluntarily self-disclosed the misconduct within 2 weeks of when the board learned of it. And as a result, the department was able to identify culpable individuals, and indeed we've announced charges against the former president and the former chief legal officer of the company for their alleged involvement in the bribery scheme. Our letter also noted, among other factors in making the declination, the following. One, the thoroughness of the company's internal investigation, the proactive and ongoing nature of its cooperation with the government in investigations and prosecutions, the effectiveness of its pre-existing compliance program, and the company's willingness to fully remediate and disgorge its entire cost savings from the bribery. Another letter from this past August provides an additional reference point. We declined prosecution in the case of the Insurance Corporation of Barbados Limited, or ICBL, despite the involvement of high-level executives in a scheme to bribe a Barbadian government official in exchange for insurance contracts. We reached that decision based in part on the company's voluntary disclosure, its significant remediation efforts, including the termination of all employees involved in the scheme, its cooperation with our investigation, and its implementation of an enhanced compliance program and more robust internal accounting controls. And the department pursued individual accountability as well, charging 2 of the company's senior executives as well as a former Barbadian official. These 2 cases make it clear that aggravating factors like high-level executive involvement in the misconduct will not necessarily preclude a declination when the company's actions are otherwise exemplary. To be sure, publishing our declination policy and letters in the Justice Manual and on our website addresses just part of the broader challenge of transparency. It's also critical that we periodically take stock of our policies themselves. We need to ensure that our policies are clear, comprehensive, and up to date. And I want to commend Deputy Attorney General Rod Rosenstein, who has undertaken the lion's share of the work on that project, and I think it has led to great results for the department and certainly greater clarity for many of you. Ensuring that our policies provide the right message and the right mix of incentives involves an ongoing process of refinement and reassessment. To that end, last October, I updated a criminal division guidance memo from 2009 on the selection of corporate monitors. We sought to update the pre-existing monitorship policy to provide more guidance about the factors that will prompt the appointment of a monitor in the first place, including how to weigh the benefits and costs of a potential monitorship, and to clarify details about the selection process and scope of monitorships. The changes to the memo was met with an interesting reaction. There were many who thought that it reflected a sort of Shakespearean policy of, first let's kill all the monitors. But that's not what it was meant to do. In fact, it was meant to provide greater clarity both to companies but also to our prosecutors to ensure that when they do recommend the appointment of a monitor, that they're doing so for the right reasons and with the right scope. Similarly, we were also in the process of updating the FCPA corporate enforcement policy to bring it in line with current practice. As members of my leadership team announced over the past year, the department now extends the principles of the corporate enforcement policy to situations where misconduct is uncovered through due diligence in the context of a merger or acquisition, or in appropriate instances through post-acquisition audits or compliance integration efforts. Applying the policy in the M&A context avoids chilling acquisition activity by law-abiding companies who might otherwise walk away from worthwhile investments due to the risk of FCPA enforcement. After all, we want law-abiding companies with strong compliance cultures to be willing to make these kinds of acquisitions. Put another way, we don't want the good corporate actors to cede the field to higher risk entities that may only perpetuate illegal conduct. The new policy also makes clear that in appropriate cases where the acquired entity presents aggravating circumstances, such as when the acquired entity's past leadership was complicit in the corruption, but has since been purged by the acquirer, a disclosing company may still receive a declination from the department. All of this is consistent with our broader objectives of rewarding companies that voluntarily self-disclose and promptly remediate after learning of misconduct. And because the only written guidance relating to this issue was contained in non-binding DOJ SEC resource guide to the FCPA, which was released in 2012, we are working to ensure that our current practice is reflected in the corporate enforcement policy itself. Additionally, in the coming months, the Criminal Division will host the first of what I anticipate will be an annual training program for our white-collar prosecutors, with a focus on how we as a department will evaluate the effectiveness of corporate compliance programs. Training is, of course, only step one in any effort to promote consistency in the exercise of prosecutorial discretion. Before we can credibly speak of conveying predictable guiding principles to the private sector, we need prosecutors all on the same page themselves. Getting prosecutors across the country in one room to reflect on recent key resolutions and walk through emerging challenges in compliance will help educate our trial attorneys on the guiding principles by which we will pursue or not pursue corporate charges. At the end of the day, we at the Department of Justice are deeply mindful of our role in ensuring greater transparency in corporate enforcement and the impact that has on the corporate community. Given my own past experience, I'd venture to guess that most, if not all of you in the room today, have had a client at one point ask some version of the following question in the course of a DOJ-facing matter. How do you think the department will react if we do X? Believe it or not, we want to help enable you to better answer those questions with greater confidence and greater credibility. It's in our own interest to do so. Exercises of prosecutorial discretion are never formulaic, but with more established markers by which both prosecutors and the private sector can conform their actions, we can expand the extent to which government and industry find themselves aligned and working towards the same ends rather than against one another. After all, companies are, in many ways, the first line of defense against corporate misconduct. Working with many of you, companies are best equipped and best positioned to evaluate risk and implement measures to prevent corporate misconduct before it occurs. And when companies are incentivized to avert at the front end through effective internal controls and compliance programs the very violations that we'd have to prosecute at the back end, that inures to the benefit of both government and industry. We have mutual interests in seeing that corporate misconduct is fairly and effectively deterred and redressed. And at the department, we will continue to do our part to advance those mutual interests. I want to thank you for allowing me to speak for a little bit of time this morning. The next panel is fascinating. I wish I wasn't hightailing it to the airport. Neil Eggleston, Maithili Raman, former Congressman Trey Gowdy, Jonathan Turley. I really do wish I could sit around and listen to this one. I learned a lot from Neil Eggleston when I was at Kirkland & Ellis and had a chance to work with him. But that's a fantastic panel that you're about to hear from. And I also am grateful that they put them after my speech, which hopefully increased participation here in the room today for my talk. But I've got to hightail it to the airport. I want to thank you all. I hope you enjoy what's left of the conference and have enjoyed your time down here in New Orleans. It's been a pleasure to be with you.